Good morning. I would like to welcome you to Conservatorship 101. My name is Wayne Cobb, and I'm an attorney and a senior partner of Cobb Counsel, LLC. In this session, we're going to be discussing the Blighted and Abandoned Property Conservatorship Act of 2008 as amended in 2014. A little background about myself. My firm is located here in Western Pennsylvania. I am the lead counsel on over 200 active conservatorship cases in Allegheny County, and I believe that you're going to be in for a very good presentation. This particular session will have two presenters. As I said, I'll be moderating. The first presenter will be Judy Berkman. She is a senior counsel for Regional Housing Legal Services, and she is well known and a relentless advocate for fair housing and fair housing practices. We will also be hearing from attorney Rick Vanderslice. He is an attorney practicing in the Philadelphia region. He's a pioneer in the conservatorship field. It is our hope that after you attend this session, you will get an understanding of the statute. You'll have a better understanding of the process of bringing a conservatorship action in both sides of the state, and that you will be able to know some of the pitfalls and some of the benefits that can occur as a result of doing a conservatorship action. We would invite you to put any questions you have into the chat. There will be someone who will be taking those questions and presenting them to us. Our first presentation will be about 15-20 minutes. We'll have another presentation which will last around that time. Then we'll have some good Q&A. We hope that you're able to learn something and that you're able to take something with you as you continue the good work in the housing area. At this time, I'm going to toss it to Judy Berkman, who will give us a presentation on Conservatorship 101. The floor is yours, Judy.
Can you hear me?
Yes.
Okay. So I think I stopped the screen share. Sorry, I'm not very techy. I'll go back to it. Morning, everybody. Oops. There we go. Can everybody see the screen? Okay. So assuming yes, hi, I'm Judy Berkman. I'm at Regional Housing Legal Services, which is a statewide organization. We're basically a nonprofit law firm, and we we represent community-based organizations and other nonprofits that develop affordable housing. And in Harrisburg, we have a utility law project. So we also do a lot of policy work, and I've been involved in both developing affordable housing and doing a lot of policy work. And one issue is always abandoned houses. So the Housing Alliance had a number of years ago, a couple decades probably now, like 10 ways you could avoid blight and combat blight. And dealing with individual abandoned properties, whether it's a house, a commercial property, or industrial property, was one of the issues. So in 2008, and it was effective in 2009, the conservatorship law was enacted and it was amended in 2014. So it's basically a shortcut to attack an abandoned vacant house and turn it into productive use and back on the tax base. So this is, I think, billed as Conservatorship 101. How does it work? Well, it does work. It works very well, but it's quite complicated. So we will dig into some of the basics. So getting started, you might want to first obviously identify a property. I think that's where all of you would start. And the best way to get started with that is to determine who at your city hall, your Department of Records, who is the last owner of record. So it could be this is probably one of the more complicated parts of the law, determining who actually owns it. If the person is not alive, are the heirs alive? So the way to get to those facts most quickly is to get a title commitment. They cost what, about $275. It's really the essential way to start, other than looking at your county and court records and to see if there are any tax liens or water liens or judgments. You know, there's some things you can do quickly yourself, but really to get a full view of what the risks are to pursuing this, because your goal is to renovate and rehab the property or demolish it and then sell it, because you can only rent it for a short time under this procedure. So the idea is to get good title at the other end. So starting work with a title agent that you respect and working with a title agent through the whole process is a good start, because I think Rick Vanderslice has found that there's also fraudulent conveyance sometimes in the chain of title. So you want to avoid those, or you have to address them. So, you know, is it worthwhile to proceed? That's your first, you know, after you identify the property, that's your first question. So in the law, the property has to be not legally occupied for the previous 12 months. There are some issues about, I just wouldn't, if there are people in it, I just wouldn't do it. I wouldn't go the route to try to prove someone's a squatter. They may have rights you don't know about. The property hasn't been actively marketed in the last 60 days. The law was changed because what people were doing, the big law firms were saying like, hey, put a vacant property up for sale at a high price and then it won't be subject to conservatorship. So now instead of the petitioner proving that in court that the property hasn't been actively marketed in the last 60 days, it's now the respondents, the owner's responsibility to say that it has been marketed. It can't be subject to a foreclosure action, and it can't be acquired within the last 6 months. And there's some other requirements about if there's been a family transfer or some other things. So then let's go to the property conditions. And these are often not hard to prove. You have to prove 3 of the following 9 property conditions: that the building or physical structure is a public nuisance. Now in Philadelphia, that's sort of a problem because our licenses and inspection doesn't have an actual category of, quote, public nuisance. So I think what Rick has been able to do is get licenses and inspection to do a statement saying that because of all the violations on the property, it constitutes a public nuisance, but that's sort of not in our code. It needs substantial rehabilitation, and none has occurred during last year. Sorry for the typo there. Whoops. And then that it's unfit for human habitation, occupancy of use. That's the third one. There's a fire risk to the building or to adjacent properties. Subject to unauthorized entry with health and safety issues, or your municipality has secured the building. It's an attractive nuisance. There's, vermin, you know, rats, vegetation. It's just physically deteriorated. So all of these are pretty easy to prove either with L&I violations or affidavits or statements and witnesses from the neighborhood. This one too, it's just this dilapidated condition injures the economic well-being of residences and business. That one I wouldn't use as one of the 3. I mean, obviously, if it is in poor condition, it does injure the economic well-being of the neighborhood. But that alone as one of the 3, I think is more qualitative, rather than sort of quantitative. I wouldn't use that as one of the 3. And obviously, if it's an attractive nuisance for illicit purposes, that's the 9th one. So what about adjacent properties? This is new. You can include in the amended version of the law, You can include an adjacent property if it's the same owner and the properties were used for a single or interrelated use. In other words, say it's a structure and it was, I don't know, a dry cleaning thing or a business or a house. So if the dry cleaner used the adjacent property as parking, or the owner of the house used the adjacent parcel for garden or also parking or other uses, that can now be included. So obviously this is a court procedure. You have to petition the court to have the property declared a subject of the conservatorship law. The petitioner can be, a mortgage holder or a secured creditor. And the first law said that within a resident or business owner within 500 feet of the property, but that's been expanded to be 2,000 feet. So if somebody is nearby owns a property, they can be a petitioner. A nonprofit corporation can be a petitioner, but in Philadelphia, it has to be a nonprofit that's, quote, I'm doing air quotes here, participated in a project within a 5-mile radius of the property. Originally, it was 1 mile, and that's been expanded to 5 miles. Actually, the municipality also has the right to be a petitioner. In some areas of the state, the municipalities are the main petitioners for conservatorship in those counties and municipalities. And there's some other specifically named petitioners. You can't do it against a public housing authority or if the owner is deployed for military service. So those are some exclusions. Whoops, questions, where? I'm sorry, I don't know what happened. Sorry, there were a lot more slides, so I will go through them. Apologize. Give me 1 second here. I'm old, so I always print things. Here we go. So the contents of the petition, the property has to obviously meet the criteria of the conservatorship. So you, in your petition, you would state why, specifics, why you are petitioning. So it's good practice to attach code violations, any kind of declaration of public nuisance you can get out of your municipality license and inspections department, affidavits from neighbors, photos, police incident reports if there was illicit activity there, fire code violations, and obviously photos, and you want to tell the story of the problem property. You also have to recommend who will be the conservator. And you have to propose a preliminary plan. And that can be a problem because as a petitioner, you haven't been in the building. So you can ask the judge for permission to go and to enter the property. I think generally Rick does it with someone, an inspector from licenses and inspections. And the preliminary plan would include cost estimates for any rehab, or obviously if it's a demolition, you would just get a demolition contractor to give an estimate for that. You also file what's called a lis pendens. That's a notice to the court, and it's filed to show that there's litigation pending over the property. And so it would be impossible for the owner to just sell it out from under the process and get title insurance for that, because the search would show the lis pendens. The preliminary plan, we have a manual, and in the, I don't know what happened to the other slides. I'm sorry. They were all there in a minute ago. And we have a manual that's on our website at rhls.org. It was done in 2011 when the law was new, and I keep wanting to amend it, but the Philadelphia Court of Common Pleas, which has issued court regulations on how these cases are to be handled, has not yet issued amendments to its court regulations. So as soon as they do that, and that's in the works now, I will amend the manual and issue a new one. But there are a lot of ideas that the Design Collaborative in Philadelphia, the volunteer architects there provided some ideas on how to go about doing a preliminary plan. So, and just a note on the Philadelphia court regulation, which I'll get to closer to the end. Originally, when this was done, Philadelphia could issue its own court regulations. But now I think there are state rules committees, and changes to, if they reissue their court regulations, they'll have to get approval from a statewide entity. So I think when I get near the end and talk about the Philadelphia court requirements, I think you may have to watch out that some of these may be adopted statewide. So the person who's a petitioner can either name someone else as petitioner, or can serve as the petitioner, as the petitioner can name someone else to serve as the conservator. Like a neighbor could find a local contractor or someone with the capability of doing the work and managing the court process. Or the petitioner can also be the conservator. It's him, her, it, their self. But basically, through this process, it's monitored by the court so that either repairs are done by the owner under court supervision, with a conservatorship sort of hovering in the background if the property is declared subject to the act, or the conservator can take over, but they still have to do everything basically with court approval. The conservator has to have the capacity to be the developer, arrange for any environmental and engineering studies, contract with an architect and a contractor, get insurance, report to the court, submit reports and accountings to the court. So it's essential also to have a lawyer be involved who's experienced in doing these, because it's really complicated. And I know the Housing Alliance initially thought this would be a neighbor-friendly thing to do pro bono, pro se, sorry, on your own without a lawyer, but it's hard. It's also possible for someone like an individual respondent to maybe get a volunteer attorney to help out if they want to fight it, or pay for a lawyer to do that. And the Philadelphia Common Pleas Court is thinking of putting together some resources for those individual respondents who may have inherited a house and started to fix it up, but they're working and they have kids and it's COVID and they're not finishing it, and it's a gentrifying area, and someone comes in and tries to file a conservatorship, and there's a lot of heartstrings to want to make sure the respondent has a chance to do the renovations themselves, and the court would like to put together resources to be able to refer those respondents to resources to help out. Then there'd be a final plan. After you do the work, you do a final, you have been entering the building, you have cost estimates, and you may need a loan to do the repairs. So you have to get approval from the court to do that. Some lenders won't lend money. I know in the Pittsburgh area, there is a consortium that does do lending for these, but sometimes you have to get a line of credit instead of a loan with a note and mortgage, because of the questions of putting a mortgage on a property you don't own. So the final plan has to have cost estimates, a financing plan, a description of the work that has to be done, or a proposal for the demolition. And it's due within 90 days of filing the petition, although some of these timelines, it might be changed, I'm not sure. Rick can maybe address that in his, has it been changed from 90 to 120 days, Rick?
Yes.
Okay, sorry about that. because these things take time. First of all, it takes time to find the heirs. After you file, you might have to find heirs, open an estate. There's a lot of issues there. So getting to the Philadelphia court procedures, the law says you file with by certified mail, return receipt requested. And the Philadelphia Court of Common Pleas, we put together a group of stakeholders. It was Rick and myself and several other stakeholders, including 2 title insurance lawyers who work for a title insurance underwriter. And we worked with the court to come up with this general court regulation, which is on our website as well. And it's part, and what they decided was that to take someone's property away or to sort of void out a holder of a mortgage that may have an interest in the property for a mortgage or a judgment against the owner, that it was wrong to do that without service of process. So basically the Philadelphia Court of Common Pleas has a special notice that's attached to the petition, and they require service of process through the regular means of serving process. Right, you get someone deliver a complaint to you and serve it on you. And then I think a bunch of the issues that Rick will probably talk about is the difficulty of finding the owners or the heirs of a deceased owner, and all the problems you have to go through to try to get those people served. And if you can't identify them, then you have to request the court to permit you to do alternative service by publishing in a newspaper, for what, 3 consecutive weeks, something like that. It gets the legal fees and the costs become a big factor in whether you want to choose to go through with one of these or not. So that's complaint has to be provided to the current owner, the city or municipality where the property is located, lien holders, and you have to post a copy on the property. So just so you know, the local rules in Philadelphia require much more due process than the statute, but heads up that it might change because of if Philadelphia proposes rules to be approved by the state body, they may make all the counties do it, or maybe not, who knows. The other thing I wanted to talk about briefly, because my time is running up and I'm sorry you're not seeing the slides, is that neighborhood groups may want to intervene. As Rick knows, because we've been on the opposite sides of some cases, on behalf of one nonprofit corporation I represent, I have represented them in court as an intervener, which means you get notices of the hearings, you get copies of the paper, the pleadings and the filings. You get to observe, even by Zoom, what the exhibits are, and you get to observe either in person when we go back to that, or by Zoom, you get to participate in the hearing. Even if you don't intervene, you can find out about the case and follow the case and observe by Zoom or observe in person, even if you're not intervening, which means you're sort of a party to the case. But I think in some complicated cases, it's worth finding a volunteer lawyer to intervene, because you do want to monitor the proceedings. So then just briefly, and I think Rick will get more into this, the distribution of the sale proceeds go to court costs, federal, state, and local liens, the costs and expenses of the sale, the principal and interest on any debt, the cost of rehab and the conservator's fees and expenses, would includes a 20% developer fee, which has been, when the law was amended to include a 20% developer fee, then the interest in pursuing these cases really bounced up. Everything's paid off in accordance with its priority, including the conservator. And then if there's anything left over, it goes to the owner. The out sales, you can use a realtor, and And if you want to use a private sale, or if the conservator wants to buy it themselves, you'd have to work with the court for seeing whether the court would want an appraisal or what kind of process the court would want to go through. And then when everything's done and the expenses are paid and the conditions are abated, the conservatorship is fulfilled, and the owner or someone can, the proceeds are properly distributed, then the conservatorship can terminate. And there's not much in the law about those ending processes, but I think now that we have a lot of experience both in Pittsburgh and in Philadelphia, there's more practical help there. And I'm sorry if I'm sure you'll provide copies of all the slides. I don't know why they didn't all show up on my screen share, and I'm not sure why my face is not showing. So I'll stop sharing my screen now.
Thank you so much, Judy. Very good presentation. At this time, we're going to toss it to Attorney Vanderslice, who will give us a presentation on some of the nuts and bolts from a practitioner standpoint of how to go about doing the conservatorship action.
Thanks, Wayne. As I get the slides started up here, just off of what Judy said, it is a very complicated process, and frankly, it's evolving over the years. It was a lot less complicated when the first few conservatorships were filed in Philadelphia, at least, and has since taken on several requirements that were not present at that time. Just a brief overview of what happens when you file a case. As Judy alluded to, you want to do substantial investigation into who owns the property. Quite often there are fraudulent conveyances. Philadelphia is known for its problems with fraudulent conveyances. While those can be addressed in a conservatorship, typically, you have to decide whether you have the appetite to do that. You figure out whether or not the proper owner is the one who's on title when you look it up by having a title report and frankly having an attorney that's handled cases that involve tangled title and can spot some of the issues. Sometimes you can tell by the notary seal that it's not a proper conveyance, not a good deed. So those are some things that you need to look out for from the initiation of the process. I mean, most of us have seen the type of properties that would qualify for this, and it's once you get into it, generally, if you have support of the community, it is not difficult to prove that it's blighted. The difficulty comes in the opposition, if there is any, and the court will generally allow the owner to have an opportunity to correct the blighting influences and municipal violations usually. So after you've done your investigation and you've reviewed the title, you've had your attorney review the title, you've found whether there are municipal citations. In Philadelphia, we call them L&I violations. You are ready to file your petition. Judy outlined a lot of the factors that should be contained in the petition. There's actually a form petition that was developed by the working group we were a part of with a lot of input from, I believe it was an intern that worked with Judy that summer. So there are form pleadings out there on the Philadelphia court website if some people who are watching this haven't done it before, but think that they have the means to try it. Once the petition is filed, the court issues, the court has initial review of the petition. and it decides whether you've claimed enough of the and provided enough of the evidence that the property meets the criteria. Generally, we attach the citations from the municipality. Photographs of the property usually are very determinative. In Philadelphia, and I'm sure in more denser parts of Pittsburgh, a lot of our row homes are brick, and the front of them, might not look too blighted, but you go around back and there is no back and a bathtub hanging out. So it's really the rear of the property in these areas is generally where you prove that it's in pretty deplorable condition, especially when it's been boarded up by your local municipality and trying to keep trespassers out. That's usually a very good indication. And in Philadelphia, and whatever whatever your local municipality's license and inspection equivalent, if they've marked it unsafe, that is generally really good evidence that the court would find at least a portion of the factors required for blight. Again, as just a practice pointer, it's some of the best evidence comes from the neighbors. The police aren't always there to see the illicit activity, or the license and inspection doesn't always know that there's water intrusion into the neighbor's property because this blighted property doesn't have a roof. So when you have people that are impacted by the property coming to court to testify, a lot of times that can be the best evidence in these cases. So when you get to the hearing stage, the initial hearing, there'll be several hearings, but the initial hearings where you want to bring your neighbors, your violations, and there are three paths that these cases can take typically. First, a lot of owners request conditional relief, which means that the court finds that the property meets the criteria and is blighted, but as Judy alluded to, the owner has the opportunity to cure that blight. Different courts require different standards for the owner to show that they have the means to repair the property. In Philadelphia, those have typically been fairly relaxed. Usually the owner is given a chance to do what they need to do. The other path is there's an appointment of a conservator. And that's where the conservator takes over, and as Judy explained, has the obligation of remediating the blight and putting the property back into productive use. Another path that has become less frequent, but sometimes happens, is the owner just decides to sell the property. The court says, well, it meets the conservatorship criteria, and but we're going to let the owner sell the property themselves. That is becoming more rare because of the amendments to the act that I'll get to in a minute. But if you're appointed conservator, the next step will be to advise the court of what your final plan is. As Judy said, generally you're not inside the building. Depending on the court, they may or may not grant you access to the building before you have to go prove that it's blighted. So when you get access to the property after you're appointed conservator, you develop your final plan, which has, mostly the interior work, because the exterior you'll be able to judge. Obviously, sometimes the roof, you can't do that, although I would strongly recommend checking Google Maps. And we've started hiring aerial photographers to get photographs of the roof and the rear with drones, rather than having to scale through alleys and debris, and it's a lot less dangerous. So a little bit more on the court process. You've identified the property, you've filed. In Philadelphia, as Judy explained, there are additional notice requirements that involve posting the property. Some courts schedule what's called a status or settlement conference, which allows the petitioner to know if someone's going to show up and contest the property. And if they are, the court can explain to them the severity of the situation. It's not just a municipal violation. This is, somebody's going to have possession of the property and somebody's going to start expending money to fix it, which becomes a lien against the property, which is one of the mechanisms that the legislature sought to secure people who are doing this. And once you have your final plan hearing, you can go ahead and do all of the remediation that you intend to do. Some conservators will do a full rehabilitation and finish with a habitable property that is ready to move in. A lot of conservators now are taking the property to what I call a secure envelope. You've addressed the blighting influences on the exterior of the property. You've addressed the structural issues on the interior. Usually it's, the interior studs and treble lighting, the little light bulbs hanging, so that a developer can purchase it out of the conservatorship and has basically a clean box that they can put in what they're looking to do with the property. That's assuming that the owner at some point does not come in and say, okay, thank you, conservator, for doing all of this. Here's what you spent on the property. Here's what you paid your attorney. I want the property back now that it's in decent condition. That was a big problem before the amendments in 2014. Really quick, we used to go into court. Owners would show up. Sometimes they would do minimal repairs. Sometimes they would just sell the property. And the person who brought the case would be out their attorney's fees and all the other costs that Judy alluded to. Typically, you're even hiring engineers to opine on whether or not the property has, structural failings. So in 2011, the legislature sought to add an incentive to bring these cases, which it defined a conservator's or developer's fee as outlined in the definition. And everybody can read it, but just real quick, it's at least $2,500 if you're bringing one of these cases. If the owner decides to pay you for all of your costs that you've incurred in making this either clean envelope or rehabilitated property, they also have to pay you 20% of those costs as a markup for the conservator having, or for the conservator's time and efforts going into this. Finally, if the property is sold by the conservator to recoup their lien, the conservator developer's fee is 20% of the sale price. Once a conservatorship is granted, this is typically the result. There have been a few that have gone through Philadelphia anyway, where the owner has, for whatever reason, been able to reimburse the conservator, but that's far from typical. So once you go through these steps, I'm sorry for the order of the slides. As Judy mentioned, there's an outsell process, and basically this is the order of priority for who gets paid out of the proceeds. Obviously, you can't sell every property to satisfy every outstanding encumbrance on it. So the legislature put together a list of who gets paid what when. I mean, and again, in the evaluation stage, as Judy alluded to, you want to see what the municipal liens are, because I know things are a little different in Pittsburgh, but or Allegheny County, but in Philadelphia, the municipal liens get paid off the top, Sometimes you can negotiate with the city, but generally you got to make sure that whatever you're doing, you take into account the municipal liens. Then the next substantial lien that's paid is the conservator's lien, which was moved up in 2014 in priority so that the conservator would be, and or petitioner would be more secure in that they're going to get reimbursed out of the proceeds of any sale or however the case resolves. I know we're getting short on time, so everybody likes pictures. This is the first conservatorship from Philadelphia that went through the entire process. This is over on St. Albans Street, if you're familiar. This is what it looked like before, and this was after. Obviously, it was a full rehabilitation, and it was put back into productive use. It was a unique property. It was able to be split into two properties, and I drive by it every now and then, and it's still in good shape. So 11 years on, it's the act is doing what it set out to do. If we had another hour, we could get into war stories, I'm sure, about things that can complicate these filings. But generally, when you're investigating, the things that you can be aware of are tangled title and whether or not the owner is deceased, and finding heirs, which can complicate these matters significantly. Other than that, I'll turn it back over to Wayne. I think we're about 10:30, so I want to leave some time for questions.
Excellent. So at this time, I'm going to ask the session host to post any questions that we have received, and I'll just ask a general question just to get the Q&A started. What are some changes that each of you would like to see to the statute that would either create more parity or make it better for you to practice under the law? Either one of you can answer that.
Well, I think that neighbor groups ought to have, instead of at the court's discretion to allow them to intervene, I think that there ought to be more of a right for neighbor groups to intervene. I mean, they may have to show good cause why they want to intervene, but right now they can be denied at the court's discretion, without criteria. Another thing is, just as a heads up, if the owner is a defunct nonprofit, you have to include the state attorney general. So they can play a helpful role, just as an aside, I guess. And that means that sometimes if your jurisdiction has an orphans court, the orphans court may have jurisdiction over a decedent's estate or a defunct nonprofit. So that's one reason why in Philadelphia we did create the court process and the pleadings that went with the court regulation, because we wanted the cases to be handled the same, whether they were an orphans court or civil court. Turned out right now the civil court's been hearing them all, but I think, Rick, you have to start some of them in orphans court. It's complicated. So straightening that out would be good, I think. And Rick mentioned on one of his last slides that you have to pay municipal liens first. Actually, it's federal, state, and local liens. So so they might be county and local jurisdictions in other than in Philadelphia. So having more of a standardized process regarding how to handle interest and penalty and how to handle the liens. Right now, I think it's on a case-by-case basis, and we have tried to encourage at least Philadelphia to come up with a process that you could go through, because that can chew up a lot of that can be a big deterrent to, I was contacted on one that it was a large commercial property, and it had ongoing, for some reason the water was not shut off, and they had $300,000 of water liens. So without the ability to get rid of that would, it was sort of a no-go for that conservatorship. There was another one that was a twin, and the other twin was owned by an attorney who knows real estate and was anxious to get this vacant abandoned twin property next to him fixed up, but there was a federal lien, so that was a stop to that. So I know how Ohio has, their law doesn't, it can't affect federal liens, but their law has what they call a conservator or receiver, whatever they call it there, has like a super lien. And so state and local liens can be wiped out. So that would be another thought. And I think sometimes the 20% flat developer fee is too generous for someone who doesn't do much work. So
I'm gonna leave that alone.
I think some of the judges would. I know it's probably not possible, but some of the judges I think would like a little more discretion to adjust the fees.
Dun, dun, dun. Judy setting the table for the advocates. All right, Richard, what's your answer to that question?
Just off of what Judy mentioned earlier when she was reviewing the statute, there isn't much on regarding what happens at the end of a conservatorship. My reading of the statute is pretty much the conservator brings these issues to the court, but there's no real procedure as to how they are to resolve, which has caused it's caused some problems in actual practice, especially where a conservator would like to purchase the property out of the conservatorship. Some judges have flat out refused to consider that in certain cases, which, the law was amended to incentivize people to use it. And I think that it would be a incentive for a lot of commercial development. I mean, obviously there would have to be some safeguards put in place, but it's, I think clarification on that would be very helpful from the legislature.
Interesting. We have not had that problem out in Allegheny County. The conservators have had the opportunity to purchase the property at a fair market value. And it's usually requiring the conservator bring in at least 2 third-party appraisals to establish the fair market value. And then we see whether or not the lien is either equal to the fair market value or, within the ballpark. And I think also sometimes it goes to what you've done inside the conservatorship. If you have a $600,000 house and you spend $6,000, no, you don't get to sell that property. Go sell it. You haven't done enough. You haven't done enough work. So I think sometimes you have some conservators who might be a little shady, trying to figure that this is a way to make money on the side and not do the work. So we have some questions here. Could a group of neighbors who formed a nonprofit to raise money to clean up a vacant lot use Act 135 to acquire the lot if they haven't done a project under the nonprofit, but own their own homes within 5 miles? So that's obviously a Philadelphia question, but there's other ways to answer this. So I'll toss it to you all and see what say you? Can a group of neighbors form a nonprofit to clean up a lot?
There are nonprofits that do conservatorships now, and I will tell you that there weren't, obviously, when the law was enacted. So the way that we qualified the nonprofits was by the members. So if a member had done a qualifying project, the answer I would say would be yes. If a member, I should say. Otherwise, they could bring the act as neighbors and find a qualified entity to serve as conservator.
So that is inside of Philadelphia. Go ahead, Judy.
So, well, I just was going to talk about if you have one parcel that's a vacant lot. I know there was one brought in Philadelphia for 2 adjacent vacant lots, and one of them had like a cement pad that may have had like a Quonset hut kind of thing over it, but it was a broken, deteriorated cement pad, and the judge granted the conservatorship. Also, they had already done the work. At any rate, I think just a vacant lot on its own is not under the law. Is that right?
It has to have a building that was
Yeah.
on.
So if it had one that was, like I said, this was really just a deteriorated cement pad that had been used for a makeshift garage, you know, it was granted, but that wasn't much of a structure. But I
Yes.
think it just no structure. I think it wouldn't qualify now under the law.
Yeah, and I
Yeah.
think that that's where you do your title search. And outside of Philadelphia, there is no 5-mile restriction. And so I would have advised that group to any one of the neighbors could bring it. If they know that there was a property that had been on a building that had been on that property, any one of the neighbors could bring it, and they could ask that the nonprofit be appointed as the conservator. But if they were all a member of the nonprofit, or their nonprofit that formed, they could bring it as a nonprofit in any county outside of Philly. So that's the restrictions that Philly have on them. Go
Also,
ahead.
the term in the law is participated in, so that can be, it's vague enough that maybe you can squeeze into it somehow.
Again, that is for Philadelphia. In a gentrifying neighborhood in Philadelphia, how would you weigh the risk of sending a property to a delinquent tax sale, or risking loss to a speculator, to cost versus time to go through the Act 135, but having more guarantee to get site control? So should you send it through the tax sale, or should you put it through the conservatorship, is the basic question in Philadelphia.
Well, I share the questioner's skepticism regarding sending properties to tax sale. For one thing, you never know when the city is going to get to it. For another, you know, as the questioner identified, you're going to have quite a bit more control of the site and what happens with it. It just comes down to whether or not the entity or person that is posing this question has the financial capability and can qualify as a petitioner and or conservator under the act, would be how I would weigh it. For me, it's, I mean, and I handle a lot of tax issues as well with real estate, and I think that Act 135 is a far superior tool to address blight, rather than waiting for it to go to tax sale.
Another alternative, though, is say it's adjacent to some other parcels that the city owns. You could ask the land bank. You could maybe, we have a land bank that I think has expedited tax sale powers and can take a property into the land bank. So I think if they knew that there was a desired purpose for it, not just randomly to do it, but they might do it through the land bank.
Are they suing Philadelphia for properties?
Who's they?
Potential conservators, petitioners. Has the city been sued as a respondent, not just a party in interest?
Once. Generally, I've counseled people to avoid it, but apparently the city resolves them fairly quickly once they're filed, at least this one that I'm aware of. I still think there are a lot of pitfalls, especially for entities that do a lot of this work. And we have a relationship with our Department of License and Inspection that I wouldn't want to, unless it was a really egregious case, I wouldn't want to put, it's a tough balancing act, but it's, you know, you want the city's participation, and if you're suing them, it becomes adversarial, which is a problem.
Good answer. Are vacant lots eligible for Act 135 if they previously had housing?
Yes.
That is also correct.
You can, a good way, again, in your investigation is the municipal liens will sometimes have a demolition lien you can look for, or, you know, Google Maps or your city's archives will a lot of times have assessments that have land and dwelling, and one year you'll see that it's just land, and that's also good evidence. So those are a few ways that you can tell when if it's had a dwelling.
Next question. What would you estimate is the average cost incurred by someone seeking a conservatorship?
Well, in Philadelphia, it can range from, you know, $8,000 to $10,000 in just attorney's fees. It depends on what you have to put up to rehabilitate the site. But we've had ones that have gone into tens of thousands of dollars. Generally, those are larger sites, or sometimes people file bankruptcy, which is another tactic that respondents use to get around, try to use to get around the act, because they're used to it with, foreclosures and municipalities enforcing their laws against them. So when you get call them a wily respondent, someone who's usually a land banking, or in the old sense of the term, not the new law, but just holding these properties as speculators, a lot of times they'll try and throw up roadblocks to a conservatorship that are not contemplated by the statute.
Yeah, and on average in Western PA, you're going to spend between 8 and 10 on legal fees. It may spend less if it's a vacant lot. But I think most of the costs that people incur are in the actual renovation. And so it depends on the size of the property. And that's something that you should know based on your plan of action when you put it together with your petition. You should have a good sense of how much money you want to spend on your project. And if you're not a novice, most of my clients aren't novices. They know how much money they're going to spend on a single family home, depending on the section of the city or the neighborhood they're in. Final question. If an owner wants to sell after a conservatorship is filed, can the petitioner just buy it from the owner and drop the conservatorship? What say you all?
That was one of the first ones that was brought. We wanted a test case to go all the way through, and a nonprofit in Philadelphia filed one of the first ones. And the owner came and he said he hadn't been in it since 1980, but he walked by it every day, so it wasn't abandoned. So there was that issue. Which is why we changed the law to say that it's abandoned, because abandoned is in the title, but it wasn't in the statute as a criteria. So anyway, so you'll see a definition of abandonment in the revised statute. So he was a lovely guy, and he got an attorney, and he got an appraisal, and the nonprofit got an appraisal, and lo and behold, the nonprofit's appraisal was a little higher, and the nonprofit bought it. So we think these settlements, where the respondent is willing to sell it or rehabs it, it wakes up and rehabs it. All of these we count as wins, because abandoned, blighted property has been resolved.
What do you think, Rick?
After the petition is filed, definitely. If the court makes a finding that the property is blighted, it gets a little more complicated. And depending on the court, a lot of times they'll either, if the conservator is appointed, the conservator will be required to finish the rehab, or if conditional relief is underway, the court will want to see that that's completed. Sometimes if you work out a settlement agreement where a purchase is part of that, the petitioner or potential conservator can take over the rehabilitation. And then once you get to the termination of the conservatorship, you put your settlement agreement in, and the new owner takes over, or the petitioner or conservator.
Excellent.
I don't know how things work out in
I was going to say, in Western PA, settlement is always welcome. We always have an open ear. We thank you so much for taking the time to listen to us talk to you about Conservatorship 101. Hopefully you were able to come up with some good information. I'm sure the slides will be available, and we thank you for participating in the session. God bless.
Take care.
Stay safe.
Stay safe.